Good afternoon, everyone. Chairperson Dr. Rodrigo, Dr. Mahana Maheva, presenters, and the distinguished audience. My paper titled as Recognizing and Respecting the Rules of the Game, the Strength of Sri Lanka's Investment Law Regime in the Context of New Generation Investment Policies, fairly a lengthy title, is based on international investment legal principles as well as contract law principles. Investment law has become a subject by itself because of its relevance of the legal principles, the inherent legal principles in the modern context. In a context where the roles of developed countries and developing countries change, and also in a context where the emerging market economies try to boom the world economy, I think Sri Lanka has a huge role to play in attracting foreign investment. Sri Lankan foreign investment, or rather foreign direct investment, was non-existent till the liberalization of trade in 1977. And today, foreign direct investment plays a paramount role in the financial account of the balance of payment. In order for the country to maintain a healthy balance of payment, and in order for the country to attract best results of investment, I think it is vital for the country to have an institutional as well as a legislative framework, which is a very strong framework in terms of international investment law. In 2012, foreign direct investment recorded the highest level for a year. That means foreign direct investment plays a huge role in the economy of Sri Lanka. Now, the reasons of this highest level were the confidence in the investors in the long-term investment, and also the macroeconomic stability Sri Lankan economy had last year. Therefore, I believe that a strong legislative and institutional framework is an imperative factor in our context. If I may try to draw a remote correlation between the game we play, Kabaddi, and foreign direct investment, when the player goes into the premises of the other team, the player right at the entrance will be powerful because he is backed by the home state economy. But subsequent to the entry, his bargaining power will be diminishing, and the host state will have a better bargaining power given the cumulative strength of the bargaining power, or rather the cumulative strength of the host state. Host state on one hand will try to attract the maximum benefits of investment, and the investor on the other hand, with the support of his home country, or rather the mother country, will also try to maximize the advantages of his own investment. But remember, unlike in Kabaddi, foreign direct investment is a game where the game itself is not hostile. The parties or the teams have to respect the rules of the game. The teams have to be fully aware of the individual targets of individual teams. And confrontations, unlike in Kabaddi, will be harmonious. And host states will always have to see that the host state retains its policy freedom, regulatory power, as soon as the investor comes down to the host state. Because the host state will have to retain this power in order to regulate the misdemeanor of the investor. According to the United Nations Conference on Trade and Development, these are the challenges that have been identified, faced by the host states. Strengthening the development dimension of international investment agreements, or we call it IIAs. Now, the approach is towards inclusive, sustainable growth of investment. It is not only economic growth, it is all about balancing social confrontations, talking about sustainable investment. Therefore, the UNCTAD regulations stipulate that there should be an inclusive growth of investment, not only economic power. And also you should balance the rights and obligations of the investor on one hand, and also the set of rights and obligations of the host state. Bhopal tragedy, you must have heard Bhopal tragedy. It was the world's worst industrial disaster. then in that case the investor led India into a very hapless plight, and the investor was not responsible. So the countries do not want to face such hapless plights in the future. So that is why UNCTAD focuses on sustainable development and also balancing of rights and obligations of the state on one hand and the investor. And also, my paper focuses on how bilateral treaty relationships maintain the systematic or manage the systematic complexity of bilateral treaties. What are the systematic complexities we find? Inconsistencies, overlaps, and also gaps. Whenever you have a gap in a bilateral treaty, arbitral tribunal will have the jurisdiction to come into. And the arbitral tribunal will always come up with an unexpected decision and also with an expansive interpretation, which is not good for the host state. Therefore, as host states mainly, as a country striving its way forward and as a country to become Asia's hub, I think Sri Lanka has to have a bilateral regime, treaty regime, which is so strong in order to curtail the jurisdiction that can be exercised by the arbitral tribunals. And also, the new generation investment policies talk about the inclusive growth of investment. And whenever the investor comes down to a host state, the BOI or the institution that handles investment, foreign investment locally, will have to keep its policy freedom, will have to keep its regulatory power. So the new generation investment agreements discuss how to create synergies between inclusive development as well as sustainable development, and also how to endow the investor with a lot of responsibility, a sense of strong responsibility and a set of rights. And also, how are we effectively drafting international investment agreements in order to curtail discrepancies? My paper focuses on the bilateral treaty regime mainly, and the first one is that the treaty obligation should be to have the regulatory power with the institution that handles foreign investment. And also the focus is sustainable development. And also this policy should be based on a strong development premise. So what are the mechanisms that Sri Lanka can resort to in bringing viable treaty mechanisms? Fortunately, Sri Lanka has recently drafted and finalized its International Investment Protection and Promotion Agreement, which has become a success and it has strongly and strictly complied with the new generation investment policy requirements. So when it comes to preambular provisions, we have to include something like sustainable development, sustainable investment. But remember, when it comes to the definition, we should not include sustainable development because it will give a lot of leeway and freedom for the other countries and also for the tribunals, arbitral tribunals to interpret in a very expansive way. So it's better to have a qualifying criteria, and also it's better to have an exhaustive list. Therefore, the tribunal will not be able to include anything which does not come under investment. This has been the case in Mihaly. The question was whether this factor came under investment or no. So the tribunal gave a very expansive interpretation to include it as investment. Therefore, it is our responsibility as the government, or it is our responsibility as the institution which seeks to attract investment to have very strict definitions of investment. The scope of application, you can always eradicate or exclude portfolio investment if you are only dealing with foreign direct investment. You can have connotations like sustainable development, but remember the problematic areas should always be excluded. This is how you set your bilateral treaty regime to attract investment in a very strong manner. The standard of treatment. You can either treat the investor as our own national, or you can ask what kind of international treatment he requires. Is it most favored nation? Is it fair and equitable treatment? Likewise. But remember, the policy requirement, the policy space, and the regulatory power should always be retained by the institution that handles it. Dispute settlement. In terms of dispute settlement, World Investment Report of 2012 says that the countries have expressly stated their reluctance to go before arbitral tribunals. They have a lot of discontent with the current dispute settlement. This is due to a lot of things: unexpected, unanticipated use of definitions, inconsistent precedents, challenges against policy measures, and also costly and lengthy processes. Therefore, I think, as the previous speaker said, if we can bring up or establish our own arbitral tribunal, and also if we can restore the confidence the investors had in our courts and also in our local procedures, I think we will be successful. These are the challenges that we face when we move forward. Identify improvements to the regulatory institutional framework and also to introduce strong bilateral relationships, and then always address the continuous systematic assessment of arbitral jurisprudence. In my paper, I conclude that policy space and regulatory power of the institution that handles foreign direct investment should not be misconceived as manipulation that brings about inconsistencies in the setup of foreign investment. The goal is to utilize that policy space or policy freedom in order to bring about strong economic power and balance social confrontations. Therefore, treaty provisions have to be maintained and negotiation processes have to be brought about in order to achieve this. Thank you.